And we are here today in the case of Mackey versus Woodford, case number 20AP40, which is a case pending in the 10th District Court of Appeals. We are here this afternoon for a hearing pursuant to Ohio Revised Code 232351 and Appellate Rule 23. We are doing this virtually in light of COVID, and I'm going to first set a few ground rules for everyone. If you are not speaking at the time, I will ask you to turn your microphones off. I think we're okay if you want to keep your video on, but feel free also to turn your video off. But we certainly need you to turn your microphone off if you're not speaking. Also, we have a court reporter here with us today, although I don't see her on our screen anymore. Oh, there she is. Yes, I'm sorry. We have a court reporter. She will be transcribing everything that happens today. She also will be in charge of any exhibits that are offered and admitted. She has a copy with her of the exhibits that were sent prior to this hearing. What we will do today, we are going to conduct a hearing pursuant to the statute. The first issue that we will determine is whether or not there's any particular conduct that is frivolous. We are not going to announce any decisions today, but I want to give you an outline of what the hearing will encompass. And then the second issue that we will need to determine is if there was any particular conduct that the court deems as frivolous, whether or not any party was adversely affected by it. And finally, if so, it will be up to the court to determine what amount, if any, award to be given. Those are the issues that the court will decide and the issues that will be addressed today. I want to emphasize it is a limited hearing. Those are the limited issues that are before us today. It is an evidentiary hearing, so both sides have the right to call witnesses and to cross-examine any witnesses called by the opponent, and also each side has the opportunity to present any additional evidence that they wish the court to consider. With that being said, I think that probably covers everything. I will also be administering the oath to any witness who intends to testify. And if for appellees, if you can introduce yourself and let me know who will be offering the evidence and making the arguments today.
Have to get used to the mute button. Kristen Rosen, Your Honors, on behalf of the appellee Alex Mackey, and I will be presenting argument today on behalf of appellee. Appellee will be testifying as to items 1 and 2 of the outline that you provided, whether or not the conduct is frivolous and whether or not he's been adversely affected by the conduct. And then it was my intention to be sworn and provide testimony as to the reasonableness of the attorney's fees, which is one of the exhibits that we have in our packet of materials.
All right, thank you, Ms. Rosen.
Thank you.
Mr. Woodford, I know you at one time were considering obtaining counsel for this hearing. I assume that you are proceeding this afternoon pro se. Oh, and you'll need to unmute yourself whenever you speak.
Yes, I am, Your Honor.
All right, thank you, sir. With that being said, Ms. Rosen, you may call your first witness.
Thank you, Your Honors. I would like to call Alex Mackey, who's the appellee, to the stand, the virtual stand, to be sworn and provide testimony.
Mr. Mackey, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give this court will be the truth and nothing but the truth, either under penalty of perjury or so help you God?
I do.
Thank you. You may begin, Ms. Rosen.
Thank you, Your Honor. One, I guess, housekeeping matter before we start. I did previously submit to the court and to Mr. Woodford our exhibit packet, and I just want to make sure that either electronic or paper copies have been provided to the judges. And then, of course, Mr. Woodford.
We have them all, so does the court reporter.
Wonderful, thank you. Mr. Mackey, if you would introduce yourself by stating your name and spelling your last name for the court reporter.
My full name's Alexander Mackey, Alexander Mackey, Macke, middle initial J.
And what is, if you could give the court just kind of a background of your relationship, both to this case and then the cases that kind of preceded this case involving Mr. Woodford.
This case was in response to an appeal of a granted protection order, a 5-year protection order. I believe the appeal to the order was in January 2020, and then ultimately the appeal was dismissed in the end of June 2020. This is a separate case, but it's compounded to other cases, one that goes back to as far as 2012 versus a condo association that was ultimately dismissed by the appellant. And then a very similar identical case, which was filed against the condo association. And at that time I was on the board of directors and still am, which was filed in 2015 and has been ongoing in Common Pleas Court of Franklin County with Judge Holbrook. And that started in 2015, it's still not done. Then there was a 2018 case that Mr. Woodford filed shortly after the protection order hearing started. And he filed a case against my LLC, which is Madison Bryden LLC, which is how I hold my properties in title. They're 2 investment properties. That case was filed in 2018 against several people, including myself and my LLC. Mr. Woodford dismissed that case and I took the high road, and I could have gone for attorney's fees on it, considering there were other cases already in, but I just wanted to move forward in my life. And then in January, the appeal of the protection order came, and you know, there's 2 protection orders, one for me and one for my father. My father resides in the 1620 Park Tower building. I do not. I do have 2 rental properties there. Mr. Woodford chose to only appeal my protection order, which is parallel and runs congruently with my father's protection order. So there was kind of, you know, I was confused as why are we just appealing my protection order? And then he dismissed it 6 months later.
Mr. Mackey, do you have personal knowledge of the facts related to the case, the appeal at issue, and then the damages that you believe you sustained?
I do.
Okay, so I'm going to ask you to look first at Exhibit A.
Mhm.
Do you recognize this document?
I do.
Okay, and what is it?
It's the ultimate lawsuit of voluntary dismissal by Mr. Woodford against Park Towers, and originally, which was I think with a bunch of other people, that ultimately whittled down to just Mr. Woodford, and he withdrew this. He withdrew this case, and I think that was somewhere in 2013.
Okay, and then take a look next at Exhibit B. Do you recognize that document?
Yeah, and Exhibit B was the 2018 case that he filed in the fall of 18 after the protection order hearing started. And then that was against, I was, my LLC, Madison Bryden, was named in it, so I had to hire an attorney to do my answer.
Okay.
That was ultimately dismissed.
Okay, and then going next to Exhibit C, do you recognize that document? And if so, give us a description as to what it involves.
Exhibit C is a pending case. It's a vexatious litigation case where 2 defense or 2 insurance provider carriers. One is RSUI Insurance, and I think the other is Philadelphia Insurance. They are our condo board and director insurance policies. Those 2 insurance carriers, since there were 2 lawsuits and separate peoples in Mr. Woodford's, they represent individual parties who serve or have served on the board. Both of those insurance carriers approached our condo association and decided they wanted to file suit independently on Mr. Woodford to have him declared a vexatious litigator. And that's
And
still ongoing too.
And are you a plaintiff in that case?
I believe I am a plaintiff in that case as well as the condo association and other people.
Okay. And that case is currently pending?
It is.
Okay. And then look next to Exhibit D. Do you recognize that document?
Yes,
Let's talk about Exhibit D and Exhibit E. Do you recognize that one as well?
I do.
Okay. And what are those two documents?
There were two bankruptcy filings of Mr. Woodford's. And it was unclear, but I think in the first one, he didn't have an attorney when he filed, and the bankruptcy trustee dismissed the case. And then there was a second filing in which he did retain an attorney. And that one was ultimately tossed by the district trustee of bankruptcy court. And in those bankruptcy courts, it stalled. The bankruptcy, filing stopped every other court proceeding we had going on for about 6 months.
Okay. And what was the effect of the bankruptcy stay on the other court proceedings? Did that harm you in any way?
It prolonged everything, and it still has prolonged everything to the fact that the big case, the 15 case, is still ongoing in court.
Okay. Moving next to Exhibit F. Do you recognize that document?
Yes, this is the appeal that he filed against my protection order in January 2020 and dismissed it effectively June 25th, 2020.
Okay. And then was there back up a little bit and just give the court a brief summary of the protection order and the duality of the protection orders between your father's CPO and your CPO?
Somewhere in 2013 or 14, Mr. Woodford made the claim that he would financially break me and bankrupt the condo association that I'm a board of director on, and that he would go to no means to stop it. And he'd always, has in past, put on shows and like to attract things. And at that point, he started daily protests out in front of where my parents live, where he hired people for $10 an hour off Craigslist, put my name all over Craigslist, that I was a crook, a fraud, a drug addict, a career criminal, hired homeless people. I mean, it was straight out of like a movie you would never see. And they had bullhorns, and the bullhorns screamed everything from Alex Mackey is a gay man, Alex Mackey smokes weed, my father smokes weed, we're all crooks, we should all be in jail. The place is bankrupt, it's bed bug infested, anything and everything. And he was doing it to try to do what he was out to do, which was bankrupt that association and push it into receivership. Over about a 2-year period of this, it got, when he first said, I'm going to bankrupt you, you're not fixing anything. I at that point just said the attorneys can handle it. If he's going to say he's going to bankrupt me and do harm, the attorneys will handle it. And the attorneys did from that point. So I ignored it. And for every day that I ignored it, he tried another tactic. And ultimately culminated in the summer of 2018, where the protesters were blocking people's entry. It was scaring off people who were coming to see their doctors, who we have commercial offices on the first floor of the building. A lot of people with some special needs, and they're getting bombarded by hostile protesters out front that don't live there. It got worse and worse, and Mr. Woodford showed up out front dressed in a SWAT uniform one morning and pulled out a 2-foot machete and made various claims that he wasn't there to kill white people. More police calls came in. And then he walked into the lobby and told the manager he was coming back with his conceal and carry, and he was going to use it on Frank Mackey, my father, who's on the board of directors, and his little gay son. And the next morning, I'm sorry, that happened the day before the protection order was filed. The day we went, then the next morning at 9 a.m. to file the protection orders, he was out front of the building with the 2-foot machete, dressed in SWAT costume. The police came, they confiscated the machete, took it away from him, and then an emergency protection order was granted. It took 1 year and 3 months to get the final order on that. So we were back and forth through court. It's been an agonizing few years. I will never get back.
The civil protection order for your father and yourself, did the magistrate hold a hearing?
Several, and in that, more really jarring things came out, like Mr. Woodford had already had a civil protection order against a lady in a previous matter about 15 years earlier for 5 years, where he said he was going to go blow up her family and knock them all off. So this wasn't his first time dealing with a civil protection order. And I'm telling you, it has been a jarring experience. I don't leave my house. I don't leave my house without looking over my shoulder. I only walk when I have my 2 dogs with me. Every time I hear a loud bullhorn, I think my name's going to come out of it. Someone asked me, why would he just appeal yours? Do you think he wants to come protest in front of your office or your house? And I said, I honestly don't know, but I don't think he gets the viewing capacity that he does on East Broad Street in Columbus when 100 or 200,000 cars drive by a day. It's all about a show. If you make it bad enough, they'll all leave.
So at the conclusion, Alex, after the conclusion of your evidentiary hearing for the CPO, did the judge issue a decision?
Ultimately, the judge issued the decision, but it was about 1 year and 3 months after the hearings concluded because something happened to the magistrate. There was an illness or something, and all of her cases went on hold. But there was a point in that time from when they were still reviewing that it expired for like a day, or there was a renewal. And at that point in the renewal of the temporary order, and this was prior to what the police, I think, ultimately did arrest him for violation, but he did enter the Park Tower building. And he did come in during the terms of the protection order. And his attorney at the time even confirmed that prior to that weekend on Friday, he let Mr. Woodford know the protection order had been temporarily extended. Fast forward then to probably a month or 2 later, and this would have been in the January, February, March 2020, Mr. Woodford was still going on Craigslist on a daily fashion under gigs, posting my name, specifics, hiring protesters, where to be at. I want all felons. I want all homeless people, and ultimately the police, the Columbus police, did arrest him and found him in violation for the protection order, which was very clear that said he should have no direct or indirect contact with anyone in that, with the person in that protection order. He or no one else that he is an agent for should have contact. And even though he was maybe 1,000 feet away, he was organizing daily protests with my name on it, my father's name on it, other people on my board of directors.
Okay, so Alex, let's back up just real quick. So back to the civil protection order, the court issues a decision. After the court issues a decision, did Mr. Woodford file any objections or order a transcript of the proceedings?
No, he didn't.
Okay.
That
then the next-
time, that expired completely.
Okay, so the next you hear from Mr. Woodford on this case was the filing of the instant appeal.
Yes, which again, it accomplished nothing because my father has the identical protection order till August 2023. If he needed to get anything done in appealing the protection order, he would have needed to appeal both of them and had a transcript along with the appeal. I can't run out and represent myself. I will always hire an attorney. And furthermore, my properties are in an LLC. I am the sole member of that LLC. I can't answer on behalf of my LLC. I have to have an attorney answering on my behalf.
So you testified about criminal charges that were levied against Mr. Woodford for violation of the protection order. Has that case, that criminal case, gone to trial yet?
Not yet.
Okay,
So
that's still pending.
Yeah, it's still pending.
Okay. So moving on, do you believe that Mr. Woodford's filing of this appeal was intended to harass you? And if so, why?
100%.
Okay. And why do you think it was intended to harass you?
Back to the original thing of I will bankrupt you in this place if I have to.
Okay.
I mean, it's bankrupt. Bankrupt isn't just about money. You can mentally bankrupt someone. You can physically bankrupt someone. You can make their daily routine totally opposite of what it has been for 35 years of their life.
And how has Mr. Woodford's actions in filing this appeal adversely affected you?
It's definitely made me stronger than I was the day before, and know to, expect the unexpected every day. And I can't really look to try to find the logic in Mr. Woodford's motives or motions, because I think looking for logic from the logical person is going to get you nowhere. But I had the opportunity when this 2018 case happened, and I took the high road. I wanted it done. I wanted it over. I wanted to move forward with what I need to do as far as the head of that board of directors for that condo association for the other 149 unit owners there.
I'm going to ask you to look next at Exhibit G.
Yes.
Do you recognize this document?
Yes, it's your ledger of attorney's fees.
Okay. Is it a true and accurate record of fees that have been billed to you on this case?
Yes, it has.
Okay. And what's the total amount of attorney's fees that you have incurred through today, estimated through today's hearing?
$8,456.25.
Okay. And there's a couple hours there estimated there at the bottom. Do you see that?
Yes.
Okay. Are you satisfied with the services that Madison and Rosin has provided for you in this appeal?
Yes, I am.
Okay. Now, one question that you may be asked is, up until the time Mr. Woodford filed his dismissal, you had only spent about $1,000 in attorney's fees. Does that sound about right?
Correct.
Okay. Why did you make the decision to incur additional fees to pursue your frivolous conduct motion?
Because it could happen 8 more times on 8 more different things and 8 more lawsuits he would file against me or my LLC. And I think it says enough in the evidence that you provided that there's already 2 large insurance indemnity and companies that felt the same too.
Okay.
Again, a pro bono, plaintiff can go in and get online and file whatever he wants. I have the responsibility to answer that.
Okay. I have nothing further, Mr. Mackey.
Thank you.
Mr. Woodford, you have the opportunity, if you'd like, to ask Mr. Mackey any questions in cross-examination. Would you like to
Thank
ask?
you.
Would you like to ask any questions?
Yes, I would.
All right, go ahead.
Good afternoon, Mr. Mackey. I would like to start this from the beginning and give the panel a full understanding of what all of these lawsuits are about. Your attorney spoke to the 2012 lawsuit. What is your actual knowledge on that suit itself? Have you reviewed that suit, and did you understand that suit of 2012?
At some time I did, but not in the recent past. I knew that was the beginning and that it was dismissed.
Was it dismissed with prejudice or without prejudice?
I don't know to answer that right now.
Do you remember any of the causes of actions in that lawsuit?
No, it was before my time at Park Tower, but I think the general action was they were unhappy with the manager. They were unhappy with the management company, and they were unhappy with the board of directors at that time. And there were owners behind it.
But you had testified that the 2015 lawsuit was a continuation of the 2012 lawsuit. How did you know that?
Because when it was filed, the attorneys clearly said this is pretty much a duplicate of the 2012 lawsuit, plus an addition of a couple other items.
So as president of the association, have you reviewed the 2012 lawsuit?
I haven't, I read it at one point, but that probably was about 5 years ago at this point.
So the components of that lawsuit was that important to you or not as president of Park Towers Association?
The health of where my parents live, my friends live, and 150 unit owners is my priority. And anything that makes that place healthy and well, I am all for. And I will go to the ends of the earth to get it for all those people. And I did read that lawsuit, the 2012 lawsuit, and I want to say in full, I read it, and it probably was around the time of the 2015 filing.
Okay. Part of what you're alleging here in attaining your lawyer fees of $8,000 plus, $8,840, $8,456.25. The Ohio Revised Code is pretty clear that all parties pay their own attorney fees under the American rule. Did your attorney explain this to you?
Objection, Your Honor.
Okay. Do you understand that?
Sustained. And because we're doing this virtually, it's going to be a little bit more difficult. But once an objection is made, if everybody can stop talking, and then I'll make a ruling and then you can proceed. I'm sustaining that objection. So Mr. Woodford, you may ask your next question.
Okay. The 2012 lawsuit, you said you read that. Did you understand the causes of actions in that lawsuit?
In general, I understood the lawsuit, but I can't point to the causes of action in that lawsuit at this point.
But aren't you a party to the law? Are you a party to the lawsuit that's alleging that I'm a vexatious litigator?
Yes.
So you're alleging that 2012 lawsuit was vexatious.
I'm alleging, and I don't see how this parlays into where we're at now, but it seemed to be a pattern of a lawsuit that was dismissed already by you, and then you refiled another one independently without people standing behind you in 2015. And bear in mind, I was not an owner in that complex till probably 2014 or 15.
Okay, but what I'm suggesting is that you filed a vexatious litigator case that is, according to the records here, let's go back to that. If I could take you back to exhibit, I think I want to say it's exhibit C. Let's go over that document, sir. Do you have exhibit C up, Mr. Mackey?
I don't have the full case up. I just have the date in the case on my.
No, the filing that your attorney filed she's using as exhibits today. She just brought it to your attention.
Mm-hmm.
Exhibits A, E, C. You just went over those and said you understood those.
Yes.
Okay, I want to bring you to exhibit C. Would you pull that up, please?
I don't know how I can pull that up while I'm on Zoom. Kristen, are you able to pull that up?
So you don't have a copy of it?
Not with me sitting here.
Okay, but you answered.
I have an appeal that you had written.
Okay, so you just responded to her exhibit C when she asked you a question.
Yeah.
And you responded to it.
Yeah.
I want you to go back to that.
That vexatious filing was done by the two insurance companies.
Okay, but let's take a look here. Who were the plaintiffs, Mr. Mackey, in that vexatious litigator case? Up at the top, you'll see in the Court of Common Pleas, Civil Division, plaintiffs. There are 3 of them. We're not talking about who paid for it. I'm asking you who's the plaintiff in that case against Carl H. Woodford.
Your Honor, if I might, just to help move this along, Mr. Mackey, the paper copies of the exhibits, I just emailed you a second copy in case you didn't print those out.
Complaint for vexatious litigator. I have it here. The plaintiffs are Jinx Beekler, Alex Mackey, and Frank Mackey. And
Okay, all right.
that would be simple because we were on the board of directors. They needed the board of directors.
Okay, so so we talk about being a vexatious litigator. I'd like you to scroll down to paragraph number 24.
Yep, 24.
Okay, that talks about the 2012 case, right?
24 says further, Woodford has a documented history of vexatious conduct and other lawsuits where he has consistently and repeatedly ignored court orders and been found in contempt of court and been sanctioned for his conduct.
Okay, the next sentence right there between that and 25 is the 2012 pro se litigation.
Yes.
What do you know about that case that you could tell? I'll go back to the same question. What were the causes of action in that case?
276 allegation complaint filed on February 1st, 2012. Breach of contract as to the association and board members, breach of fiduciary duty, fraud, unjust enrichment to town properties in Miss Beechler and Miss Neal, conversion, civil conspiracy, violation of the Ohio Corrupt Activity. And that's all that is on here with those 7 listed.
Okay, so I'm assuming before you filed this vexatious litigator case, did you read the 2012 case?
I read the 2012 case at some point.
So, but the most important thing is you filed this vexatious litigator case in what year? When did you file your vexatious litigator case, Mr. Mackey?
2019.
Okay, so in 2019, before you filed this case against me, you're telling me that you did not go over the 2012 case in which you were calling me a vexatious litigator?
I said I completely went over that case, and it was prior to the 2015 case that is now in motion with the court. I had read the 2012 case prior to your filing, and I think simultaneously or around the same time you filed the 2015, because it was said that these are very, very similar claims and accusations in this case and the one that was already dismissed.
It was said by whom? That's hearsay. It was said. As a president of an organization, I would think you would have read this yourself and not relied on hearsay. So my question is, the basis of this vexatious case that you filed on January 8th, 2019, just about almost 2 years ago, I'm asking you what out of that 2012 case was vexatious? Please explain to the courts.
Carl, I'm not here to answer that, nor am I prepared for that right now.
Anytime you take the stand as a witness, we're giving the court a fundamental basis.
Okay, so I guess
Let him finish his question, Mr. Mackey, and then you can answer.
What I'm saying here to Mr. Mackey, when you file a lawsuit again, these aren't playthings. This is very serious business. And the question is, you're the president of a 161 unit, 67 unit condo high rise that houses your parents, and you have a duty to treat all parties equally. Is that true or false?
I would, yeah, definitely.
It's
I
true
will
or
treat
false?
everyone equally. I will give everyone the benefit.
Just
of the
yes or
doubt.
no?
Yes.
Okay. So when you decided to pull the trigger and filed this lawsuit alleging Mr. Woodford to be a vexatious litigator. How much homework, what due diligence did you perform on the 2012 case to put that in there as a cause of action? Please answer.
The 2015 case alleges the same stuff as the 2012 case, clearly.
But where are you getting the information? You said you heard.
I
Or
read
someone
it.
told you.
I'm looking at it right here, the same with the 2015 case. You're upset with the board of directors, you're upset with the management company, and you make a lot of claims in it.
And I'm upset. Okay, so the 2012 case, how many parties were co-plaintiffs in that case?
The 2012 case, again, I'd have to get the amount of people, but I think you started out with 20 or so and ended up with yourself when you dismissed it.
Okay, would you please tell the courts who told you that the 2012 case was similar to the 2015 case? Who told you that?
I read the two cases and I came up with that conclusion on my own. And at the same point, I think the defense counsel attorneys said the same. These are all, or the attorney counsel said this is very similar to the other one. And it was
So your
shortly
answer
after,
is the attorney told you that.
and it was shortly after you sat on the front wall and said, I will bankrupt this place if I have to.
Was that, what was on the front wall that said that?
You said that when you were dressed up at one of your protests. And it was right at the point you looked at me and said, Mackie, you're not getting in, your people aren't getting in to fix any problems on my roof because it weakens a count in my lawsuit. And you said,
where was I at
will
when I said that to you?
bankrupt this place if I have to and send it to receivership.
Where was I when I said that?
That would have been probably in 2014-ish, right around the time you filed this lawsuit, 2015-ish. It's all a blur because I have never been in my life in court over anything. And I work hard all day long to give back more than I take. And at this point, I'm sitting here on an appeals for a protection order that was two protection orders for two people. And you appealed only mine without ordering a transfer.
Okay, that's not part of the answer, but okay, who is Aries Quality Properties?
Kareem Smith.
Okay, and what was his involvement with the 2012 lawsuit?
I think he was a resident and an owner who was probably unhappy with the management at that time and the board of directors.
What was his involvement with the lawsuit of 2012? Do you know?
He was a party to it.
Was he a defendant or was he a plaintiff?
He was a plaintiff with you.
Okay, why did now is he a client of yours? Have you guys done business before in the past?
I've known Kareem for probably 20 years and I've sold him.
It's a yes, these are yes or no questions. They're very simple.
I know Kareem.
Is he a client of yours? Have you ever sold a property for him?
Yes.
You have. How many? How many properties have you sold for Kareem Smith is the first question.
Over the years, probably in the neighborhood of better of 40.
So better of 40 properties you sold to Kareem Smith. How many have you sold for him where he was the seller?
I think there's probably a few there. Again, I'm not prepared to look on this in my records of 20 years of selling property.
Just give us a round number as to how many have you sold more than 10 properties for Kareem Smith throughout the years? Have you sold more than 10 properties for
I
him?
have done definitely more on the buying in for Kareem because he's one of my longtime investors.
That's not the question. Stay with the question.
I'm telling you.
It's yes or no. Have you sold more than
Mr. Woodford, Mr. Mackey, I'm going to ask each of you not to talk over each other. It's very, very difficult for us to hear and for the reporter to hear. And I want both of you wait for the other one to stop.
Yes, ma'am.
Mr. Woodford will finish his question, and then Mr. Woodford, I'm going to ask you to allow Mr. Mackey to finish his answer.
Okay, going back to the question, have you sold as listing agent more than 10 properties for Kareem Smith, owner of Aries Quality Properties? Yes or no?
I cannot answer that question because over 20 years' time, I cannot recall, but I can tell you on a percentage, I definitely have represented Kareem Smith in far more purchases than sales. Far more. And this
have you
is
sold-
probably 17 to 20 years in working with him. Far more purchases where he used to do a lot of bank-owned distressed property purchases, would hold them as rentals. I have sold properties for him, but I really can't give you a firm number because I'm not prepared with that information.
Have you sold more than 5 properties for Mr. Kareem Smith over a 20-year relationship?
I think that number probably would be safe without, but I would need to go through my complete 20 years of real estate records to give you that number. I can tell you I have done a lot more purchases for him, and I could probably, on my hands, think of more purchases than sales.
Let's do it this way. How many total transactions have you been involved with Kareem Smith, purchasing and selling? Over 20?
Over 20 at least, yeah. I mean, I've
40?
done this.
Your
I
Honor,
like
Your
that.
Honor, I'm going to object here. I think that Mr. Mackey has more than exhausted his recollection of the number of purchases in response to Mr. Woodford's question.
Well, I think we might be getting further afield than some of the issues that are before us, but I am going to let Mr. Woodford ask the final question. I think I see where he is going. Mr. Woodford, I'm going to let you ask one more final question on this subject, and then I'll ask you to move on.
So it's safe to say that Mr. Kareem Smith, owner of Aries Properties, was a client of yours. You've made that clear.
Is a
Okay.
client.
He was the lead plaintiff in the 2012 lawsuit. Did you know that?
I knew he was a part of a group of owners that was spearheaded by you in that lawsuit, and they all one by one changed and walked away from that lawsuit.
Do you think he's a pretty prudent business person?
I do.
Do you think he would be part of a frivolous lawsuit?
I think at the time before,
That's yes or no answer.
I don't know.
Would your client be a party, the lead plaintiff, in a lawsuit that was unfounded and frivolous? Yes or no?
I would think if it came out with the knowledge of where this has gone 7-8 years after, most definitely, because I think there was a wolf leading the herd of sheep.
You still have failed to answer the question, Mr. Mackey. Would Kareem Smith, prudent businessman, your client, and owner of properties at Park Towers, file or be a party and put his good name on a frivolous lawsuit as
Your
lead
Honor,
plaintiff?
Your Honor, I'm going
It's yes or
to,
no?
Your Honor, I'm going to object. Mr. Mackey doesn't have the ability to answer for what somebody else's decision was to be a plaintiff in a lawsuit.
It was
Well,
before my time.
sustained, and I think it's been asked and answered. Mr.
Okay,
Woodford, I'll ask you to move on. Thanks.
I will. Okay, so what we're talking, and this is huge here because the 2012 case, if that doesn't prove to be baseless, or if it proves to be with merit, and it transitions to the 2015 case. So I'm going to go ahead and ask Mr. Mackey, again, you're a smart man. You're the president of the association. On the 2012 lawsuit, how many motions were denied that were filed by the defendant?
I don't
Do you know?
I do not know.
How many motions filed by Kareem Smith, myself, and others were approved and granted by the courts?
I do not know.
if I said 80% of our motions were approved, would you at that point think the 2012 lawsuit was vexatious or frivolous?
I think it was ultimately dismissed. And
That's not
so
the
what
question.
was the point of it?
Mr. Mackey, we're going to do this again. It's a question I want a yes or no answer.
No,
If 80% of motions in a case were approved, filed by the plaintiffs, being Kareem Smith of Aries Properties, Carl Woodford, and say 13 other co-plaintiffs, if 80% of those motions were approved, that means the judge, we filed a motion, he granted that motion. If 80% were approved, at that point, do you think that would be a frivolous lawsuit? Yes or no?
yes, because there's still 20% out there.
Okay. Okay. Have you looked at the case in its entirety to determine how many of our motions were, okay, I submitted exhibits to the court. Do you have those with you?
I've got a copy of them right here, which is your written exhibit, your appeal.
I mean, do you see my exhibits?
I see your appeal. And then we start with exhibit 1.
Okay, what does exhibit 1, what does exhibit 1 say?
Exhibit 1 is, it looks like the 2015 case filing in Judge Schneider's courtroom, 15 CV 2863.
Okay, and what document are you looking at as exhibit 1?
Decision and entry granting plaintiff's motion to dismiss defendant's counterclaim.
Would you please read the first couple pages of that decision? Because that was a big decision.
This matter
Just
came
read the
before-
first page for the courts.
This matter came before the court on plaintiff's motion to dismiss defendant's counterclaim to plaintiff as a vexatious litigator under revised code 23-2352. The court finds the plaintiff motions to be well taken and grants the same. Background: in 2012, plaintiff and many of the defendants currently before the court were involved in a civil matter concerning similar issues brought in the current case. In 2014, the parties to this matter dismissed their claims without prejudice. Earlier this year, plaintiff filed a new case against defendants alleging breach of contract, breach of fiduciary duty, fraud, unjust enrichment, conversion, personal injury due to neglect, and civil conspiracy. In their answer, defendants raise a counterclaim seeking to deem plaintiff Carl Woodford a vexatious litigator under 23-2352. The plaintiff now moves to dismiss the counterclaim. The court now addresses the issue below. The motion to dismiss standard and construing a claim for purposes of...
I don't mean to interrupt here, but we do have these exhibits in front of us. I don't think, Mr. Woodford, Mr. Mackey, there's any reason to read through an entire exhibit. We do have them.
Okay,
If
that's
you
fine.
if you will limit it
Let's
to
move on.
questions.
Okay, that's
that you
fine. So,
have.
Mr. Mackey, you've just read that exhibit 1. What does that mean to you? What does that say to the courts?
In 2012, there was a suit that involved you, and then you filed another suit in 2015.
So that decision that you just read, what does that mean to you?
That there was a court case that was voluntarily withdrawn in 2012 and a refiled one in 2015.
Okay, that's not the answer. Looking at what does that motion grants me what? What does it say? We filed a motion. Did it get denied or approved or granted by the courts?
Your Honor, objection, the record speaks for itself.
Sustained.
Okay, well, what I'm trying to get through here is whether Mr. Mackey took the time to read through this entire lawsuit page by page, line item by line item. Did you do that, Mr. Mackey?
I'm sorry, we had a technology blurb and there was about 15 seconds there that I had
Okay.
a frozen screen. And the last thing I heard was, did I do that, Mr. Mackey?
Have you read through the 2000, you see the exhibit right there.
Mm-hmm.
So does that exhibit grant me what I was looking for, or does it not?
I don't know, Carl.
So you don't know.
Carl, this is all foreign to me. I'm there to run a building, to make sure it's staffed, to make sure a 60-year-old building runs. Why did you file this to begin with?
You filed a vexatious litigator case against
Mr. Mackey, this isn't the time for you to be asking questions to Mr. Woodford or Mr. Woodford you to be answering. And let me go back to something I said at the beginning of this. Mr. Woodford, you are entitled to fully cross-examine Mr. Mackey. The issue before this court is a limited one, as I outlined at the beginning. And so I want you to focus in your questions on issues that would go to whether or not there was conduct that would be deemed frivolous. And if so, the other issues that I outlined, including whether any fees should be awarded. What this isn't is a time for you and Mr. Mackey to argue and re-argue things that have already been judicially decided by another court. But I will permit you to fully cross-examine him and ask him any questions bearing on the issues that are before us.
Well, Your Honor, I appreciate that, and I think that it's truly important for me to get all this out, because Mr. Mackey, these are some very heavy allegations that he has brought against me throughout the years, and I want the courts to fully understand and recognize, did Mr. Mackey do this on his own, or was this just a way to further bother Mr. Woodford, or did he really think about filing a vexatious litigator case against me and do his actual due diligence? And I'm trying to unearth these questions as to why he filed this case he brought in 2012. And I'm going to keep moving on as we keep going here, of course, to cover the other cases. But I want to, what's his actual knowledge? What's his factual basis for filing these actions against me as we look at this stalking protection order and all these other things? I'm trying to get, I don't want to leave one stone unturned. That's my issue here. That's all I'm trying to get to. So, okay, so back to Mr. Mackey. I would like, okay, so we've got, what's the next exhibit that you have on hand, Mr. Mackey? He's out again.
Okay, going through, I have an exhibit 3.
What does it say?
In the Franklin County Court of Common Pleas Civil Division. And this is the Judge Holbrook 2015 case that's still in action. And it says Park Towers Condo Association is the defendant. Or I'm sorry, Carl Woodford is the plaintiff in 15 CV 2863. And then there's another one that says Jinx Beekler is the plaintiff in a separate lawsuit, which is 2015 CVH 07683, Carl Woodford, the defendant. Jinx Beekler, the plaintiff, and case number 2019 CVH 01180, Carl Woodford, the defendants. And then decision and entry granting motion to consolidate these. And if I recall, this was to consolidate a case of Jinx Beekler's into the current 2015 case, correct?
You don't ask me questions, sir. I'm asking the question.
You asked what this was, and I'm asking what I believe I'm reading here is the consolidation of those two.
The document should speak for itself. I'm just asking you to read it and give me your interpretation of the document
The
that
motion of
you're-
consolidation, yes, the motion of
Okay, was that, what,
consolidation.
do you consider that a vexatious or frivolous motion?
As to what, the big picture? As to everything you've done? I mean, there's tiny pieces and parts here of everything. And for me to go on and figure out your motives and what you're behind and what you're up to, I told you the minute I stopped interacting with you, Carl, was when you said, I will bankrupt you. I will bankrupt this place. And at that moment, I said the attorneys are going to handle it from here. I need to worry about fixing an old building. And
Okay,
that's what I've done.
I'm going to direct you back to the question. You just looked at that motion,
Yes,
which was approved by the courts.
that I already said was
What the question is, was it vexatious or frivolous? As you read it. We're not asking about the 60-year-old building and you being,
I don't see anything vexatious in that court order. Because
do you see anything vexatious?
It's the order is granted by the judge. I don't see any vexatious action in Judge Holbrook. I see Judge Holbrook trying to clean up a docket of a laundry list of court items and trying to get everything blown out. And at the same point, you know, we were on good record there, and then you filed 2 bankruptcies to stall everything.
Again, I'm going back to that one motion. So you've answered the question. So you've answered the question, the motion filed, and you talked about the order not being vexatious. I'm asking you, is that motion that got us the order vexatious or frivolous?
Your Honor, I'm going to object on 2 grounds. The first, this isn't relevant to today's proceedings. I think that the court is giving great latitude to Mr. Woodford. And secondly, Mr. Mackey cannot render a legal opinion as to whether something is frivolous or vexatious. He can just testify as to how certain things impact him personally.
I'm going to sustain in part and grant in part that request. And let me give you my reasoning, just Mr. Woodford and Ms. Rosen, so you have some guidance. Ms. Rosen, you introduced as exhibits, or at least have identified as exhibits, some prior litigation, which you will, I assume, offer into evidence. Mr. Woodford is entitled to test that and to question those exhibits because you are trying to establish that there was frivolous conduct. So he is permitted and to fully cross-examine on those issues. But Mr. Woodford, I am sustaining the objection in part because you cannot simply ask the witness to read legal documents that we will or may have in front of us. You can't ask him legal opinions, but you can ask him things about what he believes formed his argument in this case, that he thinks things were vexatious or frivolous or however you want to phrase the question.
Okay, thank you. I appreciate that. So Mr. Mackey, and again, all I'm doing is going off of the documents that your attorney has prepared as exhibits, and I'm duly bound to get to the bottom of this, okay? And so you as a plaintiff, you filed this lawsuit as the president in part, and also personally, you filed this case against me as a vexatious litigator. And what I want to know before this session is over, did you know what you were filing and what you signed up for? So that's why I'm going to go through each one of these motions that you see that was presented to this court. And from your opinion, not a legal opinion, but from your own opinion as to why you came to the belief that you wanted to attach your name to this vexatious litigator case. So let's go.
Let me make a continuation of my ruling because I probably didn't articulate it very well. What this panel is not here to do and not permitted to do is litigate pending vexatious litigator case. The line of questioning that you just suggested, Mr. Woodford, goes to the merits of that case, and you will have every opportunity to ask those questions and to fully defend that litigation? Because my understanding is that's still pending.
It's still pending. Okay,
What I'm going to ask you to focus on are actions that are alleged to be frivolous in this lawsuit, the protective order lawsuit that was pending and the appeal pending in front of the 10th district. So those
Okay.
issues on vexatious litigator will be fully litigated in another forum. Those are not the focus of this hearing today.
okay, okay. Part of and I'm going to just cruise through this a little bit, but you've seen the motions that were filed and you've seen the awards of judgments for myself in the 2012 case. As we look at these exhibits, I'm going to go ahead and go to, I want to bring your attention, Mr. Mackey, to the, again, the basis of you getting your attorney fees paid by me. Under the American rule, everybody pays their own attorney fees. The question here is for you, if you look at Exhibit 11, and again, we're going to the merits of what you were calling frivolous conduct, Mr. Woodford's frivolous conduct in the past. So you have to prove frivolous conduct in order to get your attorney fees awarded. And so in past history, you know, you're alleging that I'm a frivolous, vexatious litigator doing this to harass you. Let's look at Exhibit 11. Do you have Exhibit 11 in front of you?
I believe I do. Can you tell me what I should be looking at? Because all I see is a one.
Decision and entry granting
Yep,
defendant's
I got it
motion
right here. Yep.
for preliminary injunction. You see that one?
And this is regarding the 2015, which is still currently in court, right?
This is yes, an injunction, but it's a decision made by Judge Holbrook.
No, this says Judge Schneider, who was the previous judge on the case.
Are you looking
before
at Exhibit 11?
Before Schneider. No, this is exactly what you said is,
Exhibit 11.
yeah, decision and entry filed May 4th, 2015. And it says Judge Schneider.
You're looking at the wrong one. This was filed on August 17. This was filed August 17, 2018. Exhibit 11.
Mr. Woodford, I'm not sure we have Exhibit 11.
The Exhibit 11 that you have here is decision and entry denying defendant's motion to stay discovery filed May 4th, 2015. That's where I see it end up. I have Exhibit 9. This might be Exhibit 10. And then that's where it cuts off, Carl. There's nothing after that. Then it goes to Exhibit A, B, C. And I think that's my attorney's exhibit.
Okay. All right. Well, all right. I don't know what happened there, but do you recall? Okay, so let's kind of go back to the 2000. So you understood the 2012 case. You had that understanding that there were some disgruntled owners, and you understood the lawsuit was filed. Okay, so what is your understanding of that lawsuit and why it was dismissed?
You lost people who were in your camp more than anything else. And I didn't give it much thought until the 2015 case was filed, after I had gotten to be on the board of directors and bought there, and made a very clear pledge that I was going to work above 100% effort to make that building better. And let me in, please, to fix your roof. If there's a leak, we will fix it. And your answer to me was, you're not coming in. You're not coming in. And you finally said to me, because it weakens a count in my lawsuit, and I will bankrupt this place if I have to, it's going in receivership. And at that point, as a Middleton Simpleton real estate agent, I knew what I was to do, which was let the attorneys handle it.
So,
And
okay,
then
you
go
speak,
on my daily practice of making an older structure as best as it could possibly be. And all of those people who were in your 2012 lawsuit, Carl, probably would have my back right now saying that since Alex showed up there, we've ended every year in the financial black. Our mechanic systems are in good shape. We have $1 million of new elevators. We have a new air conditioner chiller. You know, all of this deferred maintenance has been caught up. I would have never, if the roles were reversed, staged protests against you, Carl. I would have never gone to the point of brandishing a machete, dressing up homeless people like they're the Hamburglar and McDonald's characters to further ridicule their existence out front of a building of well-to-do people. I would have never gone around to insinuate there was a race war, a sexuality war, and furthermore, I would have never done it through a bullhorn announcing it to my parents and every old person in the world that this is my feeling, because I run my life with an element of decorum. And I think you got pissed off that I turned my back and said, screw it. I'm just going to keep going forward and doing what I know how to do, which is fix things, fix mechanics, fix buildings, make sure people live happy, and at best, make sure that this association ends the year in the black. I look at it as vexatious on your often bold claims of demand letters of I'll go away if you pay me $10 million, if Jinx gives me all of her properties. And you know what Judge Holbrook said very clearly in that, Carl, when you try to coerce other litigants in a lawsuit against your side, it's coercion of a witness. So there was a lot of stuff that came to me from you that wasn't, hey, come in and fix my roof. It was, I'll go away if you guys give me $10 million and all of Jinx's properties.
do you
When
have
that wasn't
some,
good enough, when that wasn't good enough, it was, I will arrange protests to make it so miserable that no one is going to want to live here. And you made that. You clearly said that. I will make it so miserable that all the white people will leave.
do you have that
Right.
documented? Do you have that documented or taped?
You have it on video on the 17th floor screaming at Jinx. They have you videoed when you said your white ass should have left years ago. I've got Channel 6 coming and everyone else. You're a bully. You're an absolute bully.
Counsel, not counsel,
never-
Mr. Woodford, Mr. Mackey,
I
I'm
never
gonna
had
say it one
anything
more
against you,
time.
Carl.
I'm going to say it one more time, and then we're going to take a break. The issue
Never
before
had
this
anything
court,
against you.
Mr. Mackey, the issue before this court is a limited one. It's whether or not there was frivolous conduct in this litigation that would justify a sanction. And if so, what should that sanction be? This is not a rehashing of old lawsuits. It is not a litigating of a pending lawsuit. It is a very limited issue. And Mr. Mackey, I'm going to ask you to limit your answers to that, and Mr. Woodford, your questions. And in a moment, I am going to take a break. So Ms. Rosen, you can talk to your client, maybe outside the presence of us, and Mr. Woodford, so you can also regroup, because it is a very narrow issue. Mr. Woodford, she did use some documents related to other litigation.
Yes,
So
you
that's
did.
why I'm giving you some leeway. The issue before this court is not whether you're a vexatious litigator. It's not who's going to win that case. It's not whether or not the condos should have been fixed a long time ago. It's a very narrow issue. So Mr. Woodford, with that, Mr. Mackey, I'm going to cut you off of your answer because you were way far afield.
I'm sorry.
Mr. Woodford, I'm going to ask you to move on. address the issues that I just articulated.
Thank you. Okay, Mr. Mackey, I hadn't really gotten into the 2015 case yet, but I guess now's a good time to do so. You had mentioned that about what do you know about our roof at 1620 East Broad Street? You've mentioned about the roof leak. Real quickly, in a few words, how long has the unit above the roof above 1620 East Broad Street, unit 1708, been leaking? How long? How many years? To your knowledge.
I know in history that a roof was replaced by Able Roof in 1996, and it's a 25-year EPM rubber membrane roof that was an overlay. I understand that early in maybe 2010 or so, you started to have roof leaking issues, and there were failed attempts at repairs. And then sometime about 2015, when you had filed your other lawsuit, you had claimed issues on it as well. I do know that over the course of my past years being president of the board, if there has been any issue brought to light of a roof leak in the suspect area, that we have immediately called our contractor, who has a contract at Park Tower for roof PM and management. They've done any repair, nail pops. It's a flat roof, and it's 17 stories up, and it's a concrete deck. I will also go further to say that our condo association has reserved properly and adequately, and we are in process of doing a full roof tear off and replacement in 2021. And that money is reserved. It is not through a special assessment, and it is going to take a lot of planning and execution because it is a very complex roof to work on. The last time I was made aware that there was any water dripping in there was when your mother had informed us, and I think this was back in April or May, and I can't be sure because I'm not prepared for that kind of timelines, but within 24 hours, we had a roof crew up there and they fixed what they found. And then your brother, Tony, every time I have talked to him, has said, it's dry up there. There's no problem. And this was even, I think, a couple weeks ago, he said, whatever you guys did the last time's worked. It's dry. I'm not saying that roof isn't 25 years old and it's due for replacement, because I'll be the first to say it's a 25-year roof with it needs replaced. We know it.
Okay, so in about 2:15 or so, were you on some kind of board with the City of Columbus, the appeals board?
Yep. I still
What was your
I'm on
position?
the appeals board, and you had called code enforcement, and it was.
I just asked you your position on that board.
Yeah,
That's all I want to know.
Yeah, and it was prior to me owning a unit in the building.
Okay, so you were what was your function at appeal board for the City of Columbus?
You hear cases, and on the date that your case was being heard,
All I want to know is what is your function? I don't want to know about my case. I didn't ask you about my case.
I'm sustaining that objection. Mr. Mackey, answer only the question that Mr.
Okay,
Wood.
yeah, I'm one of a panel of people. When someone gets code enforcement violations, they're written the right of appeal, and then they meet between an appeals board panel to try to get things worked out.
Were there orders by the City of Columbus to repair the roof above 1620 East Broad Street above unit 1708? Were there orders by the City of Columbus for the association to make those repairs? Yes or no?
If there were, and I think there was an order that a roof was found leaking and there was some frayed asbestos around a drain line. And that was then taken care of in a subsequent year. An asbestos abatement was taken care of, and the roof was ultimately fixed from where it was leaking. It took, of course, a time, but on that date of that hearing, when it was first heard, I was not present on the appeals board. And I know I wasn't present that day because it was the day that my parents were moving to unit 1504 at Park Tower, and I was
Okay,
handling the move.
that's too much information, sir.
I wasn't there.
When you weren't there, did you work for a woman named Jinx Beechler, who was an owner of 1703 about that same time?
Jinx Beekler is a client of mine. I have sold her properties over the years. I sold her big house on Brighton Road that she owned for 35
That's not the,
years.
sir, that's not the question.
So
Did you,
was she a
were you
client
employed,
that
were you
was-
employed by Jinx Beechler at the time that you were sitting on the appeals board? Yes or no?
No, because I didn't have anything for sale for her at that time.
Have you done any work for her relative to maintenance, shoveling snow on her
Yes.
properties?
Yes, I mow her one unit that's left, and if there's ever maintenance calls from any of her tenants, you know, I field it out to my maintenance guy for my real estate company.
Okay, but you just said at the time you weren't working for her because you weren't
I
selling
wouldn't
anything
have
for her.
been working for her. I wouldn't have been working for her in a capacity at that time because I don't think I had sold 765 Brighton Road, and I wasn't back at Park Tower at that time. I
But
wasn't
were
an
you
owner there.
Were you doing maintenance work for her? Were you doing things at that
No, I
time?
don't think I was doing anything at Park Tower for her at that time.
I didn't say Park Tower, any properties
No,
that she
I
owned.
don't think at that time, and it would have been totally limited to me just listing and selling her properties, which at that time was 865 Brighton Road.
Okay, that's
And
fine.
then there were a couple listings of Park Tower condos in the years that followed.
So my point is there was a relationship
Yeah.
between you and Jinx Beechler.
I've known Jinx Beekler since I was a little kid. Her nephew's a year older than me. She sponsored my soccer team growing up.
I understand, but the
I was
question is,
attorney.
is
She's
there
my
a,
parents' neighbor.
is there a business relationship at that time between you and Jinx Beechler? Yes or no?
I would have to go back and honestly look to see the dates that I started doing work for her on these properties, Carl. But I would say there was definitely a friendship there.
Okay, was she on the board at Park Towers when
I
you
believe
were on the
so.
board at the
Yeah.
appeals court with the city of
I
Columbus?
think, yeah, I think she was on the board for sure.
Okay,
I think she sat
so-
out for a little bit.
When my unit came up for appeal relative to the roof situation, did you make a decision? Were you at that meeting when they made that decision to appeal, when they challenged the appeal, when the decision came down? Were you at that meeting on that date?
I was on that meeting when and I think they had continued it, but they challenged the decision because you denied entry, and the attorneys provided 15 plus service orders where they were immediately denied entry to fix the problem, which again brings it back to the original comment to you that you had made to me is you're not getting in to fix my roof. I will bankrupt this place if I have to. And with
So
that, you did it very calculated by filing lawsuits. It drove up the insurance cost. And early on, you said very, very early on, your insurance providers will cut you off before my war chest runs out.
Do you have that in writing, or is this hearsay?
I have it in writing in all of your correspondence when you would send us report cards on Friday of how horrible and despicable people we were on the board.
Okay, so after we finish this, I
don't
want to
understand why we're talking about this because
I'm,
this is
Mr.
all
Mackey,
about.
you're arguing. I don't want to argue with you. I'm asking questions. I don't want to argue with you. You're doing it
Yeah,
again.
I'm trying to get a bare point in the compass of where this is
Oh,
going.
well, that you'll find out before this thing is over.
Okay.
So you're establishing that Jinx Beekler, owner of 1703, and you had a relationship when the appeals board made their decision on forcing the association to repair my roof.
I would need to check on the dates to see if I had any business dealings with her at that point.
Okay, very good. So the point I'm making is, did you or anybody on the board get access through a letter from me to enter that unit to make and assess the repairs and make the repairs? Do you have any letter on file stating you or any board members or management folks have the right to access that unit?
I know that there probably is a point where you said 3 people could come in, and any service people, so long that you vetted the service person, had a copy of their driver's license and it worked on your scheduling. And I think that was followed by the point you said, if anyone tries to come in that door, because we don't have a key for it, it's the one unit in the building of 100.
Okay, you're getting away from the question, Mr. Mackey.
There's
Again,
going to be a surprise behind the door for you.
I asked you,
I'm going to interrupt here because we're going to take a 5-minute break. And here's what I want to happen over that break, if you would. Mr. Woodford, I want you to, when we come back from the break, articulate to the panel why you are pursuing this line of questioning that involves apparently disputes that are either still being litigated in another forum or that have already been litigated. I want you to clearly explain to us the relevance to the narrow issue before this court.
I will do that.
And
Yes.
Ms. Rosin, I want you to articulate when we come back the relevance of the exhibits that you haven't offered them yet, but that you have talked about on why they are relevant. Because if they're relevant to your case, then they're relevant to his case. So I want both of you to articulate the relevance of that. And I want you and your client, Ms. Rosin, when we come back, I'm going to reiterate again the very narrow issue that's before this court. Mr. Satter, I'm going to ask you, is it possible for everyone to leave, and we'll stop the YouTube, and for everyone to leave this Zoom and then to come back on in 5 minutes?
I can just put everybody back in the waiting room.
All right, can you put everybody back in the waiting room and leave the judges together in the panel?
Of course.
All right, if you will do that, please. We'll take a 5-minute break. We'll reconvene at approximately 3:05.